Come in, come in.
Good afternoon, sir.
Good afternoon, Thejaswi. How are you?
I'm doing well, sir.
Please sit down. So you do editing of Wikipedia.
Yes, sir.
What section of Wikipedia do you edit?
Right, sir. So I think generally the edits that I make in Wikipedia are quite minor edits. So edits like punctuation, certain obvious factual issues. If some wrong facts are provided in an article which I'm aware of, then I try to correct that and perhaps provide a hyperlink to the actual source or citation.
Okay, so both factual and grammatical.
Yes, sir.
So factual on which area? Because you cannot be specialist in every area of.
Right, sir. So I had created a web page on criminal remedies for copyright infringement. So that was one area where I researched upon, and I compared like the US and the Indian laws on that. Other areas like regarding my university or my law school, those areas, if there's some mistakes, I try to correct them. But generally it's a very, like an amateur, I would say, level of editing.
You read books on philosophy. Which
Yes,
is
sir.
the one you have read last?
Sir, in recent times I read The Quest for a Moral Compass by Keenan Malik.
Okay, and what is the sense of the book?
Yes, sir. So it tries to trace the evolution of philosophy in a sense. It covers both Western as well as Eastern thinkers of philosophy, including in India and China. And the book is a relatively small book, just around 400 pages, but it covers most of the major world philosophies. So it's
evolution of various philosophies.
Yes, and it's an interesting encapsulation, I think, of different realms of philosophical thought.
Now tell me, in India we call it darshan, we don't call it philosophy. Why?
Yes, sir.
We have 6 schools of darshan.
Right, sir.
You know that?
So are you referring to the Vedantic schools of philosophy?
Yeah.
Yes, sir.
Yeah, you call them philosophy, I call them darshan.
Right, sir.
So why do we call them darshan?
So I believe darshan is the Sanskrit word for philosophy, and I think it's
Sanskrit came first, English came later. So darshan is the first and then English came later. But there is a fundamental difference between the two.
Yes, sir.
Do
So
you
I
know
think
that?
yes, sir. So darshan, I believe, is more of like a point of view, and it looks at unveiling the truth. Whereas I think Western philosophy tends to be a lot more
You
subjective.
see, philosophy is a mental exercise.
Yes, sir.
You argue in your mind, positive, negative, plus, minus. You do deduction, you do subtraction, you have hypothesis, and then you prove, and then you come out with an approach. That is called philosophy.
Yes, sir.
It is not based on experiencing the facts on the ground.
Right.
All the Western philosophers are like that.
I agree,
In
sir.
fact, a large number of them died in miserable conditions because they never experienced life properly.
I do agree with that view, sir.
On the other hand, Indian darshans are based on the practical experience of life.
Yes, sir.
They saw the life as it is. That's why it's called darshan. They could see it.
Right, sir.
And they became one with the Supreme. They saw it and they wrote it. Like
Right.
Upanishads or, for example, Vedas.
Yes, sir.
So it is based on the practical experience. Like you touch, the heat, you feel it, and then you can say it is hot.
Yes, sir.
But if somebody describes it, you will never understand. If you have not seen heat before, you will not understand what it is. Because
That
you have to
is
touch
true,
and
sir.
experience it.
Right, sir. I think,
So-
yes, the Indian philosophy does look at the internal experience as the most
so
important.
That is the most important difference.
sir.
Since you have Vipassana in your philosophy, so I thought I'll ask you this question.
Right, sir. That is a major distinction.
Now tell me, between law and philosophy, how does it work out? What is the relationship?
So I think law and philosophy tend to share a certain common approach in terms of the kind of ethical values that embed both philosophy and law. And in the realm of law itself, we have a specific focus on legal philosophy known as jurisprudence, and which we studied in law school as well. And it covers various thoughts by different legal thinkers.
Does the philosophy become basis of law at some stage? Because there was no law in the beginning, philosophy was there. Did the philosophy become the foundation, and then you draw the legal, act out of that, or legal laws or rules or regulations?
Yes, sir. So
Does it work
that has happened multiple times, I think.
Yes.
Thinkers like Immanuel Kant as well as John Rawls,
Yes.
they all saw philosophy as a normative grand norm on the basis of which specific legal solutions can be worked out.
Yeah, from philosophy or darshan, you come out with ethical and moral solutions, and then
Right,
get
sir.
them into a legal framework.
Right, sir.
Okay, now going to our constitution.
Sure, sir.
Recently, the Supreme Court has admitted a petition that was, I think, that the amendment to the preamble of the Constitution, which was carried out in 76,
Yes, sir.
is questionable. The decision will be taken later on, but admitted that petition that it can be questioned.
Yes, sir.
So, what is the basis of that?
Yes, sir. So the two words which were added, socialist and secular, through the 42nd Amendment,
Yeah.
They hadn't amended the date on which the amendment itself was included in the preamble. Because whereas the preamble specifically states that we, the people of India, adopt and give to ourselves this constitution on 26th November 1949. So since the date hasn't been changed, they're questioning whether they can insert new words without changing the date itself.
Okay, my last question to you is
Yes, sir.
that a law was passed by the parliament unanimously by all the parties for appointment of judges to the Supreme Court and High Courts.
Yes, sir.
And it was nullified by the Supreme Court.
Right, sir.
Do you think it was correct? Constitutionally and legally?
Yes, sir. So I believe you're referring to the 99th Constitutional Amendment of the National Judicial Appointments Commission?
Yeah, it was not constitutional amendment, it was a law.
Right.
National.
They had amended the
Constitu-
Constitution
yeah, okay,
as well.
Yeah, amendment as well, yes.
So I think the judiciary had struck down the NJAC on the idea that it violated the independence of judiciary by creating a mechanism where the judiciary did not have the final say in appointments. And I think in terms of the constitution, the independence of judiciary has now become part of the basic structure. So using the basic structure doctrine, they had indicated that independence of the judiciary was violated through the NJAC. And I feel personally that because of that judgment, we are now back to the collegium system, which again has problems.
But do you know any country in the world where the judicial appointments are done by the judiciary itself?
Yes.
In US, in any major democracy in the world? Because you have been studying on international law. Yeah.
So I don't believe that there are any other democracies, from my knowledge, where the judiciary alone carries out the appointments. In the US as well, you have the executive which appoints, and the legislature also ensures that they pass a favor in motion of that judge before
So
appointment.
don't you think the judiciary, overreached on this issue? They could have suggested amendment if they wanted,
Yes, sir.
rather than nullifying the law.
Yes, sir. So I think there was a degree of exhibition of judicial supremacy when it came to how they wanted judicial appointments to be made. I feel that it's not the judiciary's role to suggest amendments. That's something that the parliament has to do. The judiciary has to either review and accept the law or to strike down the law. And in this particular situation, they had a very narrow interpretation of what the independence of judiciary is about. They wanted full-fledged control over the judicial appointments to the Supreme Court collegium. I think that's problematic. I feel that perhaps the Supreme Court Chief Justice could have had a veto. I believe Sanjay Kishan Kaul, who recently retired, had also suggested that. And we still have the Appointments Commission with the executive involved.
Okay, thank you.
Thank you, sir.
Thejaswi, your father is from Palghat.
Yes, sir.
Where is working presently?
So he's presently working at Ahmedabad. He works at a therapeutics company called Lambda Therapeutics. It's a private research organization.
Section 482 of CRPC talks about
So it deals with remission of convicts.
but it gives inherent powers to high courts.
So I'm extremely sorry. I think I'm mistaken. Yes, sir. It gives The High Court, I believe, has inherent powers to do justice, if I'm not mistaken, in any situation where it feels it's...
Similar provision is there for Supreme Court also?
Yes, sir, in the Constitution. I believe it's Article 142.
I was reading somewhere that these days law firms are taking help of AI. In what all aspects they are taking help? Whether they can substitute the lawyers?
Yes, sir. So I don't believe that at this point in time AI has advanced to a level where it can substitute lawyers. But law firms, I think, have used the help of AI in perhaps to ensure that they have factual verification of certain arguments or laws which they're trying to invoke. They've also used it in terms of creating reasoned argumentation. So AI can help also the judiciary, for instance, to reduce the caseload by segregating case laws based on the nature of their pen.
But I think somewhere in US, some robot argued in some court or something. Remember that case?
Sir, I'm extremely sorry. I'm not.
They have used AI for arguing a case in the court.
Sorry, sir. I'm not aware of that.
One nation, one poll. Arguments in favor and against.
Yes, sir. So, in favor of simultaneous elections, one is that it reduces the cost of conducting elections. Secondly, the security deployment will be more streamlined, whereas now they have to again keep deputizing security personnel. And third, I think in terms of policies and in terms of the time spent on election campaigns, that will reduce. So politicians will have more time to focus. But there are disadvantages. One, I think it impinges on federal principles in a parliamentary democracy where it's the majority of the House that decides whether a government can be in power.
No. How? Tell me again.
So in parliamentary systems, if the party in power loses the support of the House, then they would automatically be the Council of Ministers is automatically dissolved, and you will have to have a new government being elected. And that if the legislative assembly itself is dissolved by the governor, then you would have to elect a new legislative assembly, and that could again disrupt the cycle of simultaneous elections. And so we are forcing our parties to continue in power for 5 years in a manner by having simultaneous elections. So I think that could be problematic.
Previously, elections were being held simultaneously. Even now, many state assemblies are having elections all the time, same time.
Sure, sir. I believe in the first 4 general elections, it had happened simultaneously.
Okay, without changing this, one improvement the government can do. There's one improvement which government can do without even having these simultaneous elections. What is that? Electoral rolls? Electoral rolls?
So as a uniform electoral rolls?
That can be done?
That can be done, sir, for both the state and central parliamentary elections.
That is already there. That is only one. Right. State and parliamentary election, there is one electoral roll.
Yes, sir.
There is another electoral roll for whom?
I believe for the panchayat.
Local bodies. So that can be one?
So that's also a solution, but I don't know how it would be congruent with the idea of one nation, one...
Okay, one more question. Jan Vishwas Amendment Act.
Yes, sir.
It was there last year. Yes. What it is about?
So it dealt with a number of laws and it aimed to kind of decriminalize provisions and make them more...
What does it mean, decriminalize?
So instead of imprisonment, they're imposing a fine, giving the parties another chance to pay any pending dues, for example. And the idea is to reduce the pendency of the cases before courts.
Thank you.
Thank you, sir.
Okay, Thejaswi.
Yes, sir.
Marital rape.
Right, sir.
Is a crime?
So it's not a crime at present.
And let us presume it is a crime defined in one of the criminal laws, where it will find if it is a crime.
So under the new Bharatiya Nyaya Sanhita, I believe rape...
It should find. In rape, yes. Another subsection.
Yes, sir.
Marital rape.
Right, sir.
Do you think all these murder, rape and heinous crime definition is static or dynamic in its concept? I mean, changes are happening or not?
Right, sir. So I think changes are happening in the manner in which a woman's consent, for example, is presumed. These days, in recent times, you've had issues such as drugging of victims, areas where they use
Consensus by drugging.
where they employ deceit in order to have sexual intercourse with the victim by promising marriage to her. So that I think.
Okay, that is good enough. We will go beyond.
Yes, sir.
Digital codes, we have, how much is the pendency in all the codes?
So according to the National Judicial Data Grid, we have about 5 crore cases, which are
5.2 core cases.
5.2 crores.
And Chief Justice and Prime Ministers talk about easy justice
Right, sir.
and application of all modern technology, including AI.
Right, sir.
Now, what way court procedures can be improved by video courts, digital proceedings, in your view?
So I think there's tremendous scope for the employment of technology in improving the court.
That is a general statement. Come to the specifics.
Yes, sir. So one is accessibility. You can have lawyers from across India accessing through video conferencing.
Yes.
Secondly, I believe the adjournment culture can also reduce. So you can ensure that you don't have fixed dates as and when a party is able to represent themselves before the court, they're able to come. I believe the criticism also is that the Supreme Court grants far too many adjournments to any requesting lawyer. And I think these are two major structures.
I would say entire court cases, pending cases can be segregated by big data analytics. Machine learning can reprocess the whole case history and similar cases can be identified. Lawyer's brief can be prepared and many things can be done.
I do agree that's another possibility used.
Now let us go to International Court of Justice.
Sure, sir.
Who will be prosecuted first? Prime Minister Netanyahu or President Putin? In your view, for genocide, war crime, whatever.
So the International Court of Justice only deals with state parties. So individuals like the Prime Minister of Israel, they are not going to be held accountable in front of the ICJ.
So, but South Africa was fixing him.
Right, sir. So South Africa had taken Israel to task based on the mutual signatories that they are to the Genocide Convention of 1948. And the idea of the approaching the ICJ was to invoke provisional measures that Israel would prevent any kind of genocidal intent in its actions against Gaza civilians. But the individuals itself are not going to be held responsible before the ICJ. I believe they'll have to go before the International Criminal Court.
International Criminal Court, if they go, what do they get justice?
So the International Criminal Court can prosecute individuals for such crimes of genocide, crimes against humanity, and war crimes. So, but unfortunately, as per the Rome Statute, that particular nation state has to be a signatory. And I don't believe Israel is a signatory to the ICC.
Okay. Human rights, can you define what is human rights?
Yes, sir. So I think there are a set of inviolable, indivisible rights that are granted to all human beings by virtue of their humanity.
What is law of nature?
So I think the law of nature is essentially how Thomas Hobbes would have described it as something that existed without human-made laws which tempered how nature proceeds. So
My last question, how you find Raoul's theory of justice in the Constitution and how evolution of justice, Raoul's contribution?
you're referring to John
John
Rawls?
Rawls.
Yes, sir. So I think John Rawls' theory of justice is extremely profound in our Constitution because we have a socialist approach. And John Rawls himself identified it as putting yourself in the shoes of a person who is quite poor or is handicapped in certain ways and finding ways to empower them. And we have articles in the directive principles of state policy, certain fundamental rights like how the right to life has been interpreted so broadly. And that creates a bedrock on which the state can intervene to enforce such human rights.
Do you find in preamble any reflection of John Rawls?
Yes, sir. I believe the term justice used in preamble is itself a direct.
The three dimensions of justice.
Yes, sir. Economic, political, and social.
And we the people, which political philosopher or legal philosopher sounds we the people? Constitution begins. Which philosopher sounds there?
So I'm not exactly sure. I believe it's Montesquieu who.
It is Rousseau.
Okay, I'm sorry.
General will.
Okay, sir. Sorry, sir. Thank you, sir.
So Thejaswi, we are meeting again.
Yes.
Okay, good. So let's talk something about the practice of law. We have talked so much about theory of law. Okay. So your first choice is Indian Foreign Service, no? And when we talk of law, we have Anglo-Saxon law, English law, versus the French law.
Yes, sir.
Okay. So tell me, from the foreign relations point of view, which one you will prefer and why?
Yes, sir. So the difference between these two views of law is that we have the common law, which is based on the jurisprudence evolved by British courts, and the civil law, which other countries like Germany and France have adopted. Personally, I'm more familiar with how the common law operates. We have the doctrine of precedent as well as stare decisis. So it ensures there's a degree of finality as well as predictability to the law. And I think that's ideally what the law should aim at, even in practice. So I would prefer the common law.
The English common law?
Yes.
Okay, good. And why it is important? Why it is important in today's circumstance, no?
Yes, sir.
How it meets the development aspirations of India.
Right, sir. So I think in terms of enforceability of rights, when we have a better idea of what rights are available to us, and the courts have granted those rights in previous cases, it's easier to kind of approach the courts and demand such enforcement again in cases of violation. So I think if you're trying to build a society based on socialist principles of...
No, don't talk about society. We are very mean people, no? We are very mean people. We are only, we are wanting to maintain foreign relations with a country for a particular purpose, no? Right. For a particular purpose. We are not for building up the whole of humanity. We are not responsible for that. I'm like a selfish person. I want to, my self-interest is there. So what will I prefer? English law or French law?
So I think if we were to prefer just based on our self-interests, the French law would be more appropriate. And I think certain bodies like the WTO do have that case-by-case approach. So they're not bound by any previous decisions.
Okay. So what benefit it will? For example, if we are short of critical minerals, no? Yes. And most of them are a Francophone part of Africa. Right. How does it benefit?
The law itself?
Yeah. If we adhere to Francophone law, the French laws, yes, the concept of French law, yes, okay, and if we have to have agreements with for critical minerals in Africa, yes, and if it is based on French law, right, and it is on case-to-case basis, a lot of time and resources will be spent in those transactions, no? Yes, sir. And transaction cost will be so high that it becomes uneconomical. So why should we do that?
So I do agree that it could become a situation where we might end up litigating on such disputes more often than not. But one advantage in such an approach is that if you have the real politic power like the United States or China does, then it becomes easier to...
So them follow English law?
Yeah, so if you do follow English law, I think one problem is that because it's tightly bound by precedent, then you might have to, the ideal is that you apply previous rules to the present situation as well. And so you might have situations where flexibility is not guaranteed in how we interact with other nations. But I think the civil law can allow for that.
Okay. So let's move to another topic of your interest, which is rock music.
All right, sir.
Okay. I would make a statement, no? And you should react to that. Okay. So rock has its origin in blues and jazz. Particularly blues was a very repressive form of opposition. It was an expression of opposition, right, by the erstwhile slaves, basically.
Yes, sir.
Yeah. And it was very muted kind of a opposition, and that came in the form of blues.
Yes, sir.
Okay, from that it actually rock became more expressive in terms of opposition.
Yes, sir.
Okay,
Yes, sir.
is that the reason that this kind of the rock music couldn't become very, very popular in India?
Yes, sir.
Because we are not so fond of very expressive opposition. We don't like opposition.
So I would respectfully say that's probably not the main reason. I think rock music, in the way it originated, I think is mostly based on the English language. And whereas in India we have ancient heritage languages that through which we communicate and create expression. So our music, I think, has been attuned to a different form of expression in different semantics and languages. So in that sense, I don't think it's more.
Our music has never been oppositional.
Right.
Okay? It has never been like social reformer as it has been in the West.
Yes, sir. So
Rock bands, either in Europe or in US, they have come as opposition to certain things. No, they oppose certain things which was promulgated by the society then, or government or corporates. No, and then they acted as checks and balance. That is not here. No, so that's why I would say that social reforms in India have been very, very poor.
So I think that in terms of how we've had in the medieval era Sufi music, as well as some of the Bhakti devotional music, we have in our own way maintained opposition to certain orthodox rigid practices. And I think that has been a trend not just in the US but also in India. So those kind of forms of expression through music as a form of resistance, I don't think it isn't absent in India.
Okay.
Thejaswi, ಹೇಗಿದ್ದೀರಾ?
ಚೆನ್ನಾಗಿದ್ದೀನಿ sir.
Okay. So your mother is from Andhra Pradesh and your father is from Kerala and you are born and brought up in Karnataka.
Yes, sir.
So why is that your mother tongue Telugu?
Yes, sir. So my mother is from Andhra, so she speaks Telugu and I interpreted it quite literally, so I put it as Telugu. But at home we actually converse in Tamil because my father is from Kerala, but he's a Tamilian. Palakkad district.
So you control all the 4 states of South.
Yeah, that's what it seems like.
Southern King.
Yes, sir. So we generally speak in Tamil when we are at home.
Okay. So in Bengaluru in particular, what are the issues that linguistic minorities are facing?
Panels of which I was part.
Right, sir. So I think in recent times we've had this almost superimposition of the Kannada language by certain fringe political groups, which has made minority languages feel a little endangered. Secondly, I also think that a lot of these languages are not included under the 8th schedule or given any kind of constitutional protection. So in that sense, some of the more languages which have a lesser number of speakers might be facing a threat of extinction.
So isn't that 60-40 rule of the government of Karnataka conflicting with any of the fundamental rights?
So I think in a certain, to a certain extent, it could conflict with the right of freedom of speech and expression, because it doesn't seem to squarely fit under any of the reasonable restrictions that are part of Article 19(2). But I think the idea here is to promote Kannada and ensure that there's a prominence to Kannada, but also that other languages can be shown alongside Kannada.
So what other options do we have except forcing
Right, sir.
to promote the Kannada language?
Yes, sir. So I think that forcing Kannada upon any other person is definitely not preferable. The other ways is perhaps to have local schools which teach Kannada to the students so that they're at least able to speak the language in the place where they reside. Another option is also to give the option itself to retailers to have that and perhaps provide certain incentives if you have a Kannada signboard rather than certain punishments. So I think those could be solutions.
Okay, one last question. So what is the, or say, how do you analyze the role of a public prosecutor?
So a public prosecutor functions on behalf of the government in criminal cases in order to prosecute a certain criminal, and the role of a public prosecutor is prominent because in any criminal case it's the state that prosecutes the criminal, not the victim. So the public prosecutor is representing the state, but at the same time I think he has a responsibility, albeit a non-legal one, to ensure that the interests of the victims are also protected in future.
Okay, thank you.
Thank you, sir.
All the best.
All the best.
Thank you, sir.
All the best.